Hey guys, sorry about that. The quality was kind of bad because I just uploaded it, but I just wanted you guys to see that first before I make it live. If anybody can hear me, let me know. Oh, it's live. Okay, it's not supposed to start until like 12:30, but I'll go to it now. And Susanna, if you need to hang out, go to sleep, you don't have to worry about it. There's probably not going to be a lot of people in here. Go to WJHL. I hope everyone's doing okay. Hey, Crystal. Good. All right. Give me just a second. Let me pull it up. Of course, JBBNO is going to do the live. Let's see. WFLA. Let's do WFLA. On Facebook. I hope everyone is having a fantastic day. I am, of course, allergy ridden. So I'm a little groggy, but I'm good. All right, here we go, guys. I've been waiting for this hearing for like the longest time. There's Gabby's parents. Okay, let me get the volume right. Come on, volume. How's everyone doing? Let me see. Linda. Hey, mods. Afrohuman. Carla. I don't know if y'all can hear that very well or at all. I can't. Let me refresh it. Can y'all hear any of that? I don't. Like at all. Maybe they have it like on silent or something. WFLA? Okay. That's what I thought of. Oh, I'm on Cocoa Moose. Hold on, y'all. Hold on. We're going to get it. That's where I wanted to go. I love JBBNO. Yeah, he's like talking about news right now. It can't be right. Un momento, por favor. Did he not go yet? Hold on, y'all. One quick second.
Does your insurance company want you to settle fast? Pump the brakes, hold the phone, and call 1-800-ASK-GARY.
All right. So we're waiting. I'm going to turn it on mute. Anyway, does everybody know Fbook is silent, YouTube is loud, right? I don't think they've started yet. So it's live, but it's not started. And I thought it was started. Sorry, guys. So if anybody has not... oh, look. There it is. Hold on. Never mind. Haven't followed the Petito and Laundrie lawsuit. Basically, the lawsuit states that Gabby Petito's parents is saying, look, y'all knew exactly what was going down, and you could have done X, Y, and Z to find our missing daughter. And also, you know, for when he did, in fact, murder her, you know, Brian Laundrie. So you owe us a lot of money. And I'm pretty sure they're going to use it for a good cause, like the Gabby Petito Foundation. So I think I actually have the docket here. Hold on. I'm pretty sure I do. But I completely agree with what they're doing. I think that they knew this entire time. And they deserve to get some compensation for the pain and suffering, because that's how we in America at least value damages, you know? What else can you do? Hi, Heather. How you doing, hon? So I'm going to post that Summer Wells watering hole video. It's private, I think, or it might be public, but it just needed to upload to the high definition. So y'all can go rewatch it again if you need to. I am not getting on camera today because I'm running a little late. And I didn't get to do what I gotta do to look presentable, so I'm sorry, guys. Yeah, I kind of want to go back to Coco and see what it says. See? Look. Is there like no sound, really? There we go. Let's listen to that.
Preparation for all
right.
hearings today, not simply these two cases, has been the same. The court is prepared. Whether you are joining us in person in the courtroom or via Zoom, there are two housekeeping items to address. First, only credentialed media authorized by the court's public information officer, as well as the court reporter, may record these proceedings in the courtroom or on Zoom. If you have not received that authorization in advance, you may not record these proceedings. Second, we have two cases.
Uh-oh. Does that mean that I'm illegally... Am I failing? Oh.
Which is the case involving the estates. So let's begin. The court's going to first call the case of Joseph Petito and Nicole Schmidt versus Christopher Laundrie and Roberta Laundrie, case number 2022 CA 1128. Ask the attorneys to please make their appearances and introduce their clients if they're present.
Good afternoon, Your Honor. Patrick Riley Ford, sitting to my right, Joseph Petito, and also sitting to my right, Nicole Schmidt.
Thank you. Mr. Luca?
Good afternoon, Your Honor. Matt Luca on behalf of the defendants, Christopher and Roberta Laundrie, who are not present.
Thank you very much. Now,
Oh my
we are
God, they're
to
not
hear the
present?
motion to dismiss
Come on.
filed by the Laundries, which is at document identification number, or DIN 33. The plaintiffs have filed a response, which is at DIN 38, and the defendants have filed a reply, which is at DIN 39. I've reviewed those filings as well as the other materials submitted by the parties. So, Mr. Luca, you have the floor, and if you'd like to go to the lectern, that would be great.
Yes, thank you, Your Honor.
I have to say, Your Honor, it's It's unusual to be staring at an empty spot up there at the bench.
Well, it is what it is.
What do they tell actors, Your Honor? Just find a place on the wall and stare at that? Well, thank you, Your Honor, for your time this afternoon. I appreciate it. Your Honor, I won't spend any time going through the general standard on a motion to dismiss. I know Your Honor is well aware of that, so I'll just jump right in. Your Honor, our position is straightforward. A cause of action for intentional infliction of emotional distress was not intended to include liability for a defendant who does nothing, who has no contact with the plaintiff. All of our arguments regarding outrageousness, legally permissible conduct, causation, and the presence of the plaintiff all go back to that premise and show
Look who's
why
in the
there is
background.
no
That's Bullhorn
need
Betty.
for this cause of action in this context.
Andra is back there.
Conduct
Look.
that amounts to remaining silent and maintaining privacy is not intentional infliction of emotional distress. And there are no cases where such conduct, obligation, a duty to speak, are a deliberate or reckless infliction of mental suffering, outrageous conduct, the conduct caused the emotional distress, and the distress was severe. I'll first address the outrageous conduct element, Your Honor. So the standard for determining whether or not conduct is outrageous is that the behavior claimed to constitute the intentional infliction of emotional distress must be so outrageous in character and so extreme in degree as to go beyond all possible bounds of decency. That is conduct that is atrocious and utterly intolerable in a civilized society. It is an objective standard, and the subjective response of the plaintiffs is not what controls. The issue of whether or not conduct is outrageous is a question of law and for the court to decide. And that standard is extremely high in Florida. It is not enough that the defendant acted with an intent which is tortious or even
Yeah, I thought about that.
or that the defendant intended to inflict emotional
Linda.
distress, or even that the defendant's conduct can be characterized by malice or a degree of aggravation which would entitle the plaintiff to punitive damages for another tort. Now, Your Honor, looking at the amended complaint in this case, paragraph 32 provides a summary of what the plaintiffs alleged is the conduct that was outrageous. So they allege first, failing to advise the plaintiffs that Ms. Petito was deceased. Of Ms. Petito's body. Third, taking a family vacation with their son, Brian Laundrie, who they alleged had murdered Ms. Petito while the plaintiffs were looking.
So this is what I wanted to hear right here.
Fourth, blocking access to their cell phone and Facebook page to preclude the plaintiffs from contacting them and getting information regarding Ms. Petito. And finally, that the Laundrie's attorney, not the Laundries themselves, issued a statement to the press expressing hope that the search for Ms. Petito is successful and that Ms. Petito is reunited with her family.
Is there a distinction between the attorney doing it on behalf of the Laundries versus the Laundries?
Well, Your Honor, the attorney is obviously not a defendant in this case, and there are no allegations that within the complaint that the Laundries directed the attorney to make that statement, what information the attorney had with regard to
Look
making
at the
that
attorney.
statement.
Look at Gabby's
So I
parents'
believe
attorney.
there is a
Look.
distinction, Your Honor.
He's like, yeah,
Is it
you
under
think we
Florida
don't
law,
know.
Isn't the attorney the agent of the client?
I do agree with that, Your Honor.
Then why does it matter that the attorney and not the Laundries themselves made the statement?
Well, Your Honor, what we don't know, what is not alleged in the complaint, is whether their attorney was making that statement on behalf of the Laundries or whether he was making that statement in his personal capacity.
Well, on a motion to dismiss, how am I supposed to construe the well-pled allegations?
Your Honor, on a motion to dismiss, I would argue to the court that...
Well, I'm not monetizing this live, so I don't think it's going to be an issue. Jay for Justice was monetizing it.
Defendants for purposes of making that statement, that the plaintiffs have not alleged sufficient conduct that would that would cause liability for the defendants for the statement by their attorney.
Well, assume for the sake of argument, the court concludes that there was sufficient allegations that the attorney is the agent for the Laundrie. So assume that to be true. Now we have a situation where the Laundries themselves are making a statement and not standing silent. So what does that do to your argument about staying silent?
Your Honor, I still don't.
Ooh,
I still
that's
don't
a good
think
one.
it necessarily makes a difference. I mean, I understand what the court's saying, that that if we impute that statement to the defendants, that would not be complete silence by them. However, the defendants do have a constitutional right to have an attorney and to have that attorney speak. So again, Your Honor, in my view, the attorney was merely exercising the constitutional rights of both the attorney and
No,
of the
they
client,
never spoke
by
to
making a statement.
the parents at all. You have to tell
Okay,
people.
But when you make an affirmative statement, that's the
Yes.
antithesis of staying silent, right?
I would
Exactly.
agree with that, Your Honor, yes.
You may continue.
Thank you. Your Honor, the plaintiff's claim of outrageous conduct in this context is novel. The plaintiffs have cited no cases where a person's silence except with regard to what Your Honor just raised with regard to their attorney's statement, was considered outrageous, regardless of the circumstances. And they certainly haven't cited any cases where a statement by a person's attorney has been considered outrageous. All of the cases they've cited involve some action by the defendant. Accepting the allegations of the amended complaint as true and allowing the case to proceed further would require any person and their family to speak about an alleged crime or other tragic event of which they may or may not possess knowledge, and that is simply not something
They
that
knew
our
damn
legal
well.
system
It's you
requires.
gotta
For example, if a family
find
member came
evidence
to
that they
me
knew.
and said they
But we know they
did
knew.
something terrible, the plaintiffs want the law to impose an obligation on me to then report what that family member told me. And that just isn't the law. Even if that I'm sorry, go
Let
ahead.
me
Your
make sure I understand.
The law is to report a crime to the
In
police.
your capacity as a lawyer or as just a normal person?
Just a normal person, Your Honor, just a family member.
Okay, well, does Florida recognize a privilege, a parent-child privilege?
Your Honor, I'm not arguing privilege. This could be somebody who is not a parent or child.
I don't
wife,
think they do.
husband, just anybody. My argument is not that there was a privilege between Brian Laundrie and his parents. My argument is that even if Brian Laundrie conveyed information to his parents, that they don't have a requirement then to speak with regard to that information. They don't have to share it.
Okay, well, let's.
They have to report a crime to the police.
This is where I'm having some difficulty. I fully understand and get the constitutional right to remain silent. That being said, we're on a motion to dismiss on a complaint where I have to assume the fact.
They're not going to dismiss this, and I hope they don't.
And you're trying to get me to say that the complaint itself demonstrates the existence of a right to remain silent. And I'm trying to understand how that is, or is that more of an affirmative defense that should be fleshed out in the pleadings?
Your Honor, I don't agree that it's an affirmative defense that needs to be fleshed out. I believe the court can, obviously the complaint alleges that the defendants were residents of the state of Florida, so the Constitution of Florida and the Constitution
What about
of the
failing
United
to
States
report a
applies.
criminal
If you look at
act?
the complaint,
You
Your Honor,
have-
even though it doesn't allege a formal criminal investigation,
There should be criminal charges
doesn't
against
use the
those
magic
parents.
words, so to speak. It does allege that Brian Laundrie murdered Miss Petito. It alleges that Brian Laundrie engaged in conduct to try to cover that up by sending text messages and things like that. It alleges that the defendants, his parents, the Laundries, were trying to help him escape the country. It alleges that the Laundrie family hired an attorney and then once they hired the attorney, at that point, all the contact with the plaintiff stopped. And the only statement we have is that one statement by their attorney that the court referenced. So under those circumstances, as alleged in the complaint, Your Honor, that's enough for the court to say somebody in that situation could invoke their Fifth Amendment privilege. That's not something that the court would need to find additional facts. The court does not need to look outside the four corners of the complaint. There are sufficient allegations
I don't know.
in the complaint
I don't agree.
that would trigger somebody in that situation exercising their Fifth Amendment privilege.
But not reporting a crime is not the Fifth Amendment privilege. It is
Your Honor, would you prefer that
failing to report a crime.
the outrageous element, or move on to the legally permissible element, since that seems to be
Whichever way you want to go.
Okay, thank you, Your
I'm
Honor.
not shy in asking questions.
I understand. Your Honor, the plaintiff's cause of action could also extend to somebody who, may not be in the situation where they were told something, but maybe they witnessed something, or maybe they came upon some evidence, or somehow they had some information that might be relevant to some tragic event.
Yeah, so let the jury decide.
The plaintiff's cause
And
of
don't
action
dismiss
would
this.
impose an obligation on people like that to contact the families who may be involved in that situation and disclose what they knew, or they would fear being sued. The slippery slope of allowing this cause of action to proceed would really require anyone with knowledge of events that are hurtful or which cause emotional distress to another to convey their knowledge or potentially be exposed to liability. Now, the underlying crime.
But again, I go back.
Is that statement alone sufficient to meet the standard for outrageousness? If, let's say, for example, I had, some knowledge about a crime that somebody committed, and I made a public statement about some aspect of that case, but I didn't share everything that I knew, or I hedged my bet, so to speak. Would I then be subject to liability because I shared something, but I didn't share other things? That's really the question, Your Honor.
It's where her child was. They knew.
Are we going to require them to say everything that they know?
Yeah.
Are they going to be allowed to speak freely or not speak at all? That's really the question before Your Honor. And Your Honor, I think it's important to keep in mind the standard that we're talking about here, that the conduct has to be atrocious and utterly intolerable in a civilized society. People who are faced with difficult challenges have
That
to
would
make
be
difficult
intolerable
choices.
for me.
In our society, which I would propose is civilized, recognizes at its core that things like remaining silent or speaking through an attorney are foundational rights. And those are choices that our society considers entirely tolerable. And in fact, they're codified in our founding documents. So, Your Honor, even considering the statement by the attorney, I would submit to Your Honor that's not atrocious, it's not intolerable in a civilized society for their attorney to make a statement for them like that. Your Honor, another thing I'd like to address that the plaintiffs raised in their response is that the Laundries were somehow in an unequal position to the plaintiffs, and that made their conduct particularly outrageous. Your Honor, I don't think that the standard for unequal positions is really what the plaintiffs would qualify that under this circumstance. Your Honor, in Dependable Life Insurance Company versus Harris, which is a 5th DCA case from 1987, it's cited in our papers. Your Honor, in that case, and what the plaintiffs rely upon is Restatement of Torts, Section 46, subsection E, which states this unequal position argument. And what the restatement says is, the extreme and outrageous character of the conduct may arise from an abuse by the actor of a position or a relation with another which gives him actual or apparent authority over the other or the power to affect his interests. Thus, an attempt to extort money by a threat of arrest.
Look at his
may make
face.
the
He's
actor
like,
liable even where the arrest or the threat alone would not do so. In particular, police officers,
I'm
school
gonna rip his
authorities,
face off.
landlords, and collecting creditors have been held liable for extreme abuse of their position. Even in such cases, however, the annoyances that are not extreme, even in such cases, however, the actor has not been held liable for mere insults, indignities, or annoyances that are not extreme or outrageous. So, Your Honor, in Harris, what the court recognized there is that the result of this unequal position must be something that is akin to extortion, meaning that somebody threatens another person based upon their position to cause some harm, like, you know, I'm gonna cause you to lose your job, I'm gonna cause you to be arrested, I'm gonna hurt your family, something like that. That's really what it's about. It's about somebody who has some authority to affect the person's life. It's not
Oh,
a situation
oof, this
where
lawyer.
somebody might have information that another person doesn't have and they simply don't share it. That's not really what the Harris case or what the restatement are talking about when they say unequal positions. Now, Your Honor, moving on to the assertion of illegal rights. The standard with regard to that element is that the conduct, although it would otherwise be extreme and outrageous, may be privileged under the circumstances. And the actor is never.
Yeah, apparently human life is comparable to an accident in a car. What an idiot.
Way, even though he is well aware that such insistence is certain to cause emotional distress. Now, we have several rights at play here, Your Honor. You brought up one earlier, the Fifth Amendment right to remain silent. That is certainly one of them. There's also the First Amendment right of freedom of thought, which would include both the right to speak freely and the right to not speak at all. And that was cited in Woolley versus Maynard, a Supreme Court case from 1977. Again, it's in our papers.
Aren't we responsible for the words that we say when we say them?
I would agree with that, Your Honor, certainly. Certainly, if you say words.
Johnny Depp just got found civilly liable for defamation by what his attorney said.
Sure damn did. Yep.
Again, Your Honor, I understand that in certain contexts, the statements of an attorney could potentially.
He said Johnny Depp's case. I'm giggling.
I think really what we're talking about here, though, Your Honor, is a statement by an attorney that even in and of itself is certainly not defamation, and it's not outrageous.
My understanding of the statement, and correct me if I'm wrong, is the Laundries knew, and again, this is on a motion to dismiss, so I have to accept what is alleged as true. Not that it is true, but I have to accept it as true. That the Laundries knew where the Gabby's body was, and they put out a statement in the middle of the search, hoping about the success of that search, and then not either directing them or either staying silent. I mean, that's kind of my understanding of what is being alleged.
And that is what I wanted everybody to hear. Thank God
I believe
he
that's
brought
my
that up.
understanding as well, Your Honor, that the attorney made the statement while the search was ongoing.
And knowing exactly where the Gabby's body was.
Well, Your Honor, again, that's the rub, is the plaintiffs haven't alleged anything in the complaint as to what the attorney's knowledge was when he made that statement, that he had that information.
How do you know unless you investigate that? I guess it's criminal.
The defendants had that information, but they don't allege that information was ever shared with the attorney, or that the attorney had that information when he made that statement. That's kind of the issue, is they haven't really made any allegations about the attorney and what he may or may not have known. It's really all about what the parents knew, and they don't make any allegations.
But they
about what
represent the
communicated
parents
to the attorney. So, really, the attorney's statement, again, if just looking at it within the four corners of the complaint, there really
Aren't they
isn't enough
supposed
there
to
say that whether or not when the attorney made that statement.
I think attorney is supposed to always report what they say if it's criminal. Like there's,
the case, frankly.
oh, I don't know.
And I would also submit to you, Your Honor, that statement's fairly benign. I mean, I understand in the context that they've alleged it could be construed as trying to divert attention or something like that. But Again, it's a fairly benign statement. I mean, he's really just expressing that he hopes that she returns. And again, they haven't alleged what information he had when he made that statement.
Isn't the context really what's important here? And that's what the second DCA said in that insurance case where the adjuster denied coverage and did so knowing that the person didn't have long to live and just wanted to outlive the person. And the second, which is binding on me, found that to be outrageous conduct.
That is true, though, Your Honor. In that, the second DCA said that the actions of...
Real quick, I believe that entire... what they're doing, in my opinion, is that they want that journal. And information in that journal just may explain the reasonings and the circumstances involved. Because that might play into what they knew and what the Laundries knew. This is my opinion. I can't speak for them, but I think that this is to get that journal. Because there's something, an article somewhere that said this is how they can do it. And it's like, oh my God, that's totally brilliant. So maybe that's the reason. We just can't get it dismissed.
We're talking about a statement by an attorney, sort of, boilerplate and generic, just expressing that he hopes that the search is successful and whatnot. I don't really equate those two. I mean, I do agree with your point, Your Honor, that the context is important. We do have to consider the context as alleged in the complaint in this situation. But I would just submit to Your Honor that even considering that context within the complaint, the attorney's statement is not outrageous.
You have about 5 minutes left in your argument.
Okay, thank you, Your Honor. So I'll move forward, Your Honor. I know we filed a motion and Your Honor has read it, so I'm not going to try to belabor too many points here. But with regard to the assertion of legal rights, really, the plaintiffs recognize that the Laundries have constitutional rights, and that the conduct that they have alleged within the complaint is really an exercise of those rights. So what they argue in response is that the court on a motion to dismiss shouldn't consider certain things. Number one, because they allege that within the complaint they haven't alleged state action. Number two, that they haven't alleged any constitutional rights within the complaint, and so the court shouldn't consider them. And then fourth, that the constitutional rights are affirmative defenses. Your Honor, with regard to the state action argument, as an initial matter, just because the government isn't trying to compel someone to do something doesn't mean constitutional rights don't go away. If you don't protect your own constitutional rights, even when the government's not trying to do something to you, then you would likely waive them. If the defendants in this case had made a bunch of statements, even if those statements weren't to law enforcement, those statements could absolutely be used against them. So, in that sense, Your Honor, those rights exist, irregardless of whether the state is involved. Your Honor, also, as a second point, there is state action involved here.
And maybe, this is going to be one of those cases that breaks open the accountability for what the client and the attorney say. I think they need to be recorded. Everything needs to be recorded between a client and an attorney so that if that comes into question, you could just go play it if you don't have anything to hide, but that's probably unconstitutional, but whatever.
Simply do not apply. This court cannot agree with defendant's contention
Hey, Doe.
by applying the principles enumerated in Shelley versus Kramer, which is a Supreme Court case that sort of set forth that the third branch
Hey,
of government,
Dope,
the
remind me to
judicial
throw
branch,
you a
is also
wrench.
state action. This court found and continues to find that judicial enforcement of private agreements contained in a declaration of condominium constitutes state action and brings the heretofore private conduct within the scope of the 14th Amendment, through which the First Amendment guarantee of free speech is made applicable to the states. Now, obviously, we're not dealing with a contract here or a condo association or anything like that, but the point is the same, that when a party tries to use the courts to enforce something, then there is state action. And in this case, Your Honor, the plaintiffs want the court to enter a judgment against the defendants. They presumably will want the court to enforce that judgment, and they want to use the court's authority to compel the defendants to participate in the discovery process, all of which implicates their First Amendment,
I'll toss
Fifth
it,
Amendment,
Dope.
all of their rights, Sixth Amendment right to counsel. So, Your Honor, in that regard, there is state action. I addressed the criminal investigation earlier, so I won't go through that again. Your Honor, with regard to the four corners of the complaint argument, like I said before, the Laundries are residents of Florida. It's alleged in the complaint. As such, the Constitution fully applies to them, and the court can consider those rights. The plaintiffs are essentially asking the court to force the defendants to go through discovery, pretrial proceedings, summary judgment, just to get to the point where the court finds that the defendants have constitutional rights. That's just a waste of judicial resources.
All right, you got it.
And the
Nope.
resources of the parties. Your Honor, with regard to the affirmative defense, nobody cited any cases where the legally permissible.
I know,
element
guidance,
is
same.
labeled an affirmative defense. I certainly haven't seen anything where it's the defendant's burden to prove that if there were to be a trial such that it would be an affirmative defense. Rather, the legally permissible element is really intertwined with the outrageous element. In the seminal case of Metropolitan Life versus McCarson, which is the Florida Supreme Court case that established the cause of action, the court explained how it applied in that case. And it said, the facts as a matter of law are not so outrageous in character and so extreme in degree as to go beyond all possible bounds of decency. Rather, the insurance company, according to the terms of the policy, had the right to demand proof of ineligibility for Medicaid, from Medicare. And then it goes on and it says,
How is this even
Metropolitan
relevant?
will no more than assert legal rights in a legally permissible way.
I don't
As
see-
such, Metropolitan's
I don't know.
actions are privileged under the circumstances. So, Your Honor, it's not really a defense. It's really part of the outrageous calculus.
Yeah, I saw,
The
Susanna, that you
outrageous
changed it, but I
that
was like,
the conduct
I thought you
isn't
didn't want your name
legally
known.
outrageous
But I
if
guess you're out there
is
on the YouTube
a
streets
privilege
anyway.
or a legal right that's being asserted. And Your Honor, we cite some additional cases in our reply that I'll rely upon in that regard. Your Honor also said that even if this is an affirmative defense, which I don't think it is, the court can consider an affirmative defense if it is apparent from the face of the complaint. Your Honor, we would argue that constitutional rights are apparent from the face of the complaint. They allege a crime
are
was
they
committed. They allege it.
Suing
an attorney was
insurance
hired.
company? Like, what? I don't
So
understand.
it's not a situation.
I mean, they're not. I know they're not, but it's just,
The
I
court
don't
can't
understand.
consider the defendant's constitutional rights. And in fact, in the case Huzzar versus Gross, which we cited in our papers, it's the first DCA case from 1985. It's a defamation case. And in that case, the court was considering a First Amendment privilege on a motion to dismiss and held that trial courts, upon motions to dismiss, routinely make decisions as to whether a privilege applies to protect an allegedly defamatory statement. So again, in that context, the court held that on a motion to dismiss, the court can consider a constitutional right of a defendant if that constitutional right is their defense.
Okay, well, let's just ask. I know you have identified what you contend is one crime, which is to actively assist Brian evade capture, essentially. Assuming, of course, that this is not within the four corners. I mean, we know outside of the four corners.
I bet you they have evidence from the
allegation that there was an arrest warrant out.
coroner's office
Assuming,
that
for the
has
sake of
proof.
argument, that is sufficient for purposes of us to find that there was some sort of active crime, if you will. Is there any other crime that the Laundries have been accused of or could potentially be accused of? Because before you can invoke a constitutional right to remain silent, there's got to be a crime, right?
Well, Your Honor, there doesn't necessarily have to be a crime.
Oh.
You just have to
Oh.
believe
He's like,
that you may be in
oh.
jeopardy of a potential investigation.
Well, doesn't the case
What?
talk
No.
about it has to be a chain in the causation towards a crime?
Your Honor, I don't disagree with you on that
Oh, I'm
point.
sorry,
What I'm
Susanna,
saying
my
is
eyes
there
are, like,
doesn't have to be a
horrible.
formal investigation. If
I
I
got it,
left
got
this
it.
courtroom and committed a crime and nobody knew about it, I'm not obligated to go confess that crime. Like, I can assert my silence for as long as I feel like I need to protect myself.
Well, let me ask you this, because, you know, the case law I'm familiar with.
I
is
don't
in a
like this
deposition,
asshole.
The Fifth Amendment would have to be invoked as to each specific question. So for instance, if the question is, what is your name? You might not have a Fifth Amendment right to not answer that, depending on the context of the alleged crime. So I get back to what is the crime here? And isn't that really something that we need more pleadings to be able to accurately identify so that I have a
And this
better
is where you
standard
get that
as to whether
journal.
or not your Fifth Amendment argument
Because the
actually
Laundries have it.
is applicable?
I don't think so, Your Honor. I mean, certainly the plaintiffs have alleged criminal conduct, most of which by Brian Laundrie. I'll agree with that. But they
That
do
journal
allege that the
has
Laundries,
everything.
you know,
I guarantee it.
potentially were trying to
The
assist
Laundries took it
Brian
because they
Laundrie
knew that if anybody else had it, they'd be
in
charged
leaving
with
the country.
something
Could be an obstruction,
criminal.
could be something else. There could be, you know, again, we're not leaving the complaint when we talk about that. And so in that regard, you know, the defendants still wouldn't have an obligation to speak about other things that may be sort of tangentially related to the whole situation.
He
If
sounds
there
like Benny Keys.
is potentially a crime involved. I mean, Your Honor, in Miranda versus Arizona, the Supreme Court held the privilege is fulfilled only when the person is guaranteed the right to remain silent unless he chooses to speak in unfettered exercise of his own free will. So it's the defendant's exercise. It's not something where, you know, the defendant can maintain his silence only with regard to certain things. If he's not being compelled to answer questions, he doesn't have to speak, period, at all. Again, from Miranda versus Arizona, the privilege has come rightfully to be recognized in part
AKA,
as an
say less,
individual's
fam.
substantive right,
Say
a
less.
right to a private enclave where he may lead a private life. That right is the hallmark of our democracy. So again, Your Honor, it's not, in Miranda versus Arizona, the court wasn't parsing what questions the defendant can or cannot answer. They said the right is a private enclave where a person can lead a private life. They can maintain that privacy for as long as they're able. Now, of course, like there are certain situations if defendant is subpoenaed to testify, perhaps like, you know, certain questions could be parsed, like what the person's name is or something, as long as that's not incriminating, which in some contexts it is.
Your time is up, sir. It's been 5 minutes.
You know, again, going to the plaintiff's argument, they haven't alleged that anybody was compelling anybody to do something and they refused or something like that. In that context, everybody has the right to their private enclave. They don't have to come and affirmatively state everything they know about everything. That's just not the way our society works. It's not the way, you know, it's not how the Constitution works. People are protected until they're not. And so that, in my opinion, Your Honor, I don't believe that the Laundries would have an obligation to provide certain information and not provide other information. That they can withhold all information until it's compelled of them. That's, you know, or they're provided immunity by the government or whatever the circumstance might be.
Well,
Ooh.
let's put a
What you talking about,
pin in
Willis?
that right now so I can hear from your opponent.
Yes, Your Honor. And Your Honor, for our remaining arguments, we'll just rely upon our papers unless the court has some specific questions that you'd like to address.
Thank you, sir.
May it please the court.
Hey,
Your Honor,
hey.
This case is not simply about the silence of Christopher and Roberta Laundrie, who knew that their son had brutally murdered Gabby Petito. It's not simply about their
it's getting
callous
juicy, guys.
refusal, despite pleas from the Petito family, to speak up about whether or not Gabby was alive and if she wasn't, where her body was located. It's about
Baby,
a course
I
of
agree.
conduct that they committed from the moment they learned on August 28th of 2021 that their son had brutally murdered Gabby Petito up until the time that her body was found. And as this court has already noted and pointed out,
Show me the proof.
That includes the statement that was made the one time they decided to speak up. They spoke up through their attorney, and I'll touch upon the importance of that in a little bit. As the court knows, you're bound to accept as true all of the facts alleged in the four corners of the complaint, and I'd just like to review what some of those allegations are.
Well, let me ask you this, Mr. Riley. And let's lay aside the statement that the attorney made on behalf of the Laundries. What duty did the Laundries have to do anything to help Mr. Petito and Ms. Schmidt?
That's a fair question, Your Honor, and I've struggled with the answer to that particular question, and I guess maybe by answering this I'm deflecting, but my answer is this. It's about what they did with the information that they have, not just not disclosing what they knew to the Laundries. And by the way, they could have, to the Petito family, excuse me, they could have made an anonymous phone call and said where the body was located, and that would have helped this situation tremendously. They knew, starting on August 28th of 2021, that Gabby was dead. They knew where Gabby's body was. They knew that the Petito family was desperately searching for information, but they did things affirmatively. They didn't just remain silent. Brian Laundrie came home in Gabby Petito's van by himself to his family's home. That family, knowing that Gabby was dead, knowing their son had murdered
look at her, Mama.
knowing where the body
It breaks
was,
my
and in
heart.
particular, knowing that Joseph Petito
Okay,
and
I'm
Nicole
ready, y'all.
Schmidt were desperate to learn where their daughter was located, they went on vacation. They assumed and continued their normal life as though nothing had happened, while this family was suffering, wanting to know what where their daughter was. Not only did she not...
Let's get back, though, to legal duty. I hear what you're saying, that these facts might sound bad, but, you know, we're not talking about social mores here. We're talking about legal duty.
We're talking...
So let's try to focus in on what duty did the Laundries have? What did they owe to Gabby's parents?
Well, let's put in perspective what the relationship was, Your Honor. These people were not strangers. These people were, their son was engaged to marry Gabby Petito. Gabby had lived with them for about a year. They had both visited Joseph Petito's home and Nicole Schmidt's home. They were cordial. They had a cordial relationship, a warm and friendly relationship. They knew how much Gabby meant to Joe and to Nicole. Going to the issue of a duty, Your Honor, I struggle with that. I admittedly, it's difficult to say what it is, and that's why I'm saying there was a course of conduct that they did that was outrageous, culminating, in my view, in the statement that was made by their attorney, who, as Your Honor pointed out, is their agent. And what that attorney said in particular is telling. So there's no question that he represented, that he was making that statement on behalf of the Laundries, because he says, it is our understanding that a search has been organized for Miss Petito in or near Grand Teton National Park in Wyoming on behalf of the Laundrie family. It is our hope that the search for Miss Petito is successful and that Miss Petito is reunited with her family. That statement was issued with the full knowledge and consent of the Laundries, with the full knowledge on the part of the Laundries that Gabby was not alive and that Gabby's body was located somewhere out west.
Then why didn't they have criminal charges
make a
for us,
statement
guys?
saying, we hope you find her. We hope you're reunited, giving them false hope that perhaps their daughter is still alive. If that's not outrageous, Your Honor, I don't know what is outrageous. So I think when you talk about their affirmative duty to speak up, I struggle with that. But they did speak up. And when they spoke up, they made that very callous, that very terrible statement, giving hope to Joe and Nicole that perhaps Gabby was still alive, with full knowledge that she was not. And Judge, when I talk about the course of conduct, I want to talk about some of the cases that I cited in my response to the motion, where the court found that there was outrageous conduct. And I don't see how any of these cases are any by any stretch of the imagination worse than what happened in this particular case. In the McAlpin versus Sokole case, a patient went to a hospital to have an x-ray done. She put on a hospital gown. She walked into the x-ray room, and the minute she walked into the room, the doctor began berating her in front of other staff because she hadn't paid another doctor's bill. He told her he wasn't going to treat her, and he told her that he was going to call security and have her removed from the hospital. That, according to the court, was outrageous. In Nims versus Harrison, a teacher, two students of a teacher wrote, published, and circulated a newsletter in which they had an article called Low Life, and they referred to that teacher in offensive language, threatened to kill her, threatened to rape her children, and threatened to rape their cousins. Outrageous.
Whoa.
Ford Motor Credit Company versus Shield.
Whoa.
Collection agent is unable to locate the debtor, contacts the debtor's mother, tells the debtor's mother that she's from a hospital out in California. She's trying to locate the debtor because 2 of the debtor's children have been in a serious car accident, and she wants to find the debtor so that she can let him know about this accident. The son speaks to the mother later that day, hears the story from the mother, spends the next 7 hours calling hospitals and police departments out in California, only to find out that this story was false. That was outrageous. The Dependable Life Insurance Company versus Harris case was talked about previously. In Liberty Mutual versus Stedman, the company delayed authorizing a lung transplant even though a judge of compensation claims had already ordered that they pay for the lung transplant. The carrier knew she would die without the lung transplant, so hoping the problem would go away, they denied payment in an effort to intentionally induce stress on her part to speed up her demise. The court said, under the totality of the circumstances, it's outrageous. Williams versus Mineola, and it's these 2 last cases that I'm going to cite the court to that I think are most instructive here. In Williams versus Mineola, police officers attended the autopsy of a teenage boy who had been murdered or committed suicide, and they were there with a videotape, a video camera, and a camera to record it because of the suspicion that a crime may have been committed. They took that video, they took those photos, and they took them to a party. And at the party, they shared them with other persons, including other police officers from surrounding jurisdictions, and they laughed and they joked about what was in those photographs. The court found that to be outrageous, and here's what the court said. As for what is outrageous or reckless or what is not, we emphasize that our society, as reflected, for example, in decisions of the courts of Florida cited earlier in this opinion, shows a particular solicitude for the emotional vulnerability of survivors regarding improper behavior toward the dead body of a loved one.
Bullhorn was ready to probably protest right then and there. We saw her in the back.
Dead bodies are concerned is central to our decision. This area is unique, and once it has entered behavior which in other circumstances might be merely insulting, frivolous, or careless becomes indecent, outrageous, and intolerable. One obvious reason is that the bereaved are already suffering psychic trauma because of the loss of the loved one, and are especially sensitized to any disrespect or indignity directed at the deceased body or a representation of it. The potential for severe emotional distress is enormously increased in that situation. All of this is well known to the ordinary person, and so a level of carelessness or callousness, which might not be considered tortious in other situations, can show outrageousness and recklessness when a dead body or a picture of a dead body is involved.
Well, Mr. Riley, how is a statement, "We hope this search is successful," how is that in itself outrageous?
It's a lie. It's said with knowledge that there's no hope of finding her alive because she's dead. It's said with an intention to give false hope to a family that their daughter may be alive. That's outrageous.
Preach.
This is, and at this particular point in time, they had been begging the Laundries to tell them where their daughter was, and this is the statement that they issued. The one time they chose to speak up, this was the statement that they issued. A lie that gave false hope to Gabby's parents that perhaps she might be alive. The other case,
how did they get to where she was? How did they find her?
Director's case, and I think this one may be even more instructive.
And not just because they found
In
the
that case,
van on that camera.
During I believe it was a hip transplant surgery, the decedent died. She died of cardiac arrest. What she really died, the real reason she died of cardiac arrest is because she was given an overdose of a particular medication during the surgery. And the doctors and the nurses agreed that they would not report the true reason for why she died. They would say that it resulted from complications of surgery. As a result, a complete autopsy was not done. The body was released to the family, and less than a week later, as the decedent's daughter was trying to bury her mother, she received a telephone call from the medical examiner saying, "You need to bring that body back immediately. We have to perform a complete autopsy." Again, the court said that was outrageous, and what the court said was, "We believe that the appellee's conduct in making false statements," and isn't that what Mr. Bertolino did?
But I wonder if they were trying to throw off the
We believe that the appellee's conduct
investigation.
in making false statements which led to the interruption of Mildred Thomas's funeral and the return of her body for a second, more thorough autopsy rises to the level of atrocious and utterly intolerable behavior which cannot be condoned.
They
in
probably found
civilized
cell phone
society.
pings that
As noted in Stedman, when an actor
took
has
them to
knowledge that
Teton
the other
National Park.
person is peculiarly susceptible to emotional distress, and the Laundries knew that because this family publicly said they were distressed trying to find their daughter, the actor's conduct may become heartless, flagrant, and outrageous when the actor proceeds in the face of such knowledge. We believe that in a situation where a person's loved one has died, it would be apparent to anyone that the person
We
would be
love you,
susceptible
Petito
to
family.
emotional
We're so
distress,
sorry.
and therefore, that the action of providing false information concerning the loved one's cause of death meets the standard for a claim of outrage. In this case, they provided false information, a false impression, knowing that Gabby was dead, that she was still alive and she could be found by the family if they were searching in the right place. So I also think under the restatement of Tort Section 46, comment F says, the extreme and outrageous character of the conduct may arise from the actor's knowledge that the other is peculiarly susceptible to emotional distress by reason of some physical or mental condition or peculiarity.
Yes, thank you. And the
Conduct
Schmitz
may
too,
become
yes.
heartless, flagrant, and outrageous
Gabby's
when the action
family.
proceeds in the face of such knowledge, where it would not be so if he did not know. And that's basically what the Williams court was saying, and that's what I'm saying in this instance. The Laundries knew of the fragile emotional state of Joseph Petito and Nicole Schmidt at the time that that statement was issued. They knew that she was not alive. They knew that the family was hoping to find her, and they put out a statement as though they were supporting them, saying, we too, we know she was our son's fiance, and we hope that you find that body too, or you find her and the family is reunited, excuse me. That's callous. That's callous, it's shameful, and it's outrageous. And by the way, the only reason that Mr. Bertolino is not a defendant in this action is because he's
I
not
do
a
the same
citizen.
thing
He's
with
a
my
citizen
glasses.
of the
I
state
put
of
them on,
Florida.
take them off when I'm heated. I do the same
I
thing.
think there's also support for our position under comment E to the restatement, which says unequal position of the parties in a relationship where
Well,
one
you can't
asserts and
see.
has the
It's
powers
reading
to affect
glasses.
the interest of the
But
other,
whatever.
may also supply the heightened degree of outrageousness required for a claim of intentional infliction of emotional distress. Here, the defendants clearly had the power to affect the interests of the plaintiff because they could have told them where her body was located, and
Preach.
they chose not to do so.
They were trying to find out
Well,
if they should
I don't think
keep
there's
him
any
alive or
question. There's been nothing
dead,
raised, at least by
my opinion.
counsel in his argument, that the conduct didn't cause severe emotional distress to my clients, to the extent that they would suggest and have suggested, well, they were already distressed anyway. So all we did was increase
Thank you,
their
baby,
harm.
for coming.
I guess it's okay to kick someone
Enjoy your
when they're
conference
down,
call.
according to the Laundries. But
Have a
going
wonderful
back
day.
to those two cases that I cited earlier involving dead bodies, the parties were already grieving, and it was the conduct after death that the court found was outrageous and permitted the case to move forward. So I think we have the issue of their conduct was intended to harm, or certainly what they did, they should have known was likely to cause severe emotional distress to my clients. We clearly have an outrageous conduct on their part. I think we have established that the conduct caused more emotional distress. It doesn't have to be the only cause of their distress. If it increases, that's sufficient to recover. And I don't think they're contesting at all that the emotional distress was severe. So I'll move on to the suggestion that the defendants get to raise affirmative defenses at this point in time.
Well, and thank you for doing that, because my question there is, I mean, the rule is that I can address.
You can see this has hurt him personally too.
Within the four corners, and effectively, you alleged conduct which arguably could be considered criminal on behalf of the defendants. So why can't I consider the Laundrie's constitutional right to remain silent and other constitutional rights within the context?
That's what that other lawyer was trying to say.
Well, Judge, I'm curious to find out what conduct it is that the complaint says the Laundries committed that was
Thank you for the likes,
potentially
guys.
criminal.
Got 5 are
So
missing,
if
but
the
that's all right.
answer
Thank you so
is
much.
They were harboring a fugitive. There were no charge. Again, we're outside the record, but to my knowledge, or outside the four corners of the complaint. But the complaint doesn't allege that there were any charges pending against Brian Laundrie at the time. So they couldn't have been harboring a fugitive. Are they?
I'm not sure the absence of charges is.
You weren't harboring a fugitive.
Well, Judge, what this is forcing me to do to address that is to go outside the record, which is not what we're supposed to do, to say he wasn't running. According to everything we know, the police knew where he was, so he wasn't a fugitive.
No, they
so
didn't.
weren't harboring a fugitive.
They thought they
I
did,
don't
but they
know.
weren't
Were they
at one
accessories
point.
after the fact? I don't know. Is there something they want to confess to? I'm happy to hear it, but I don't know that anywhere
too.
within the four corners of the complaint there's a suggestion that the Laundries were under investigation for a crime or that they had committed a crime. So, first of all, I think we shouldn't even be considering this as
Icky
an
Mills
affirmative
watching,
defense.
or
Secondly,
broadcasting this
you
too.
can't look at the complaint and determine was there an investigation into them and what were the crimes. So I don't think the Fifth Amendment applies. If we turn to the First Amendment, I will tell you I strongly disagree with counsel's assertion that it applies in all instances. The defendants rely on Woolley versus Maynard for the proposition that they have a constitutional right to say nothing. But Woolley says that the right of freedom of thought protected by the First Amendment against state action includes both the right to speak freely and the right to refrain from speaking at all. And we're not talking about state action in this case. The defendant says we're asking the court to force the defendants essentially to say something. That's not what we're doing. We're seeking damages for their conduct. More importantly, the First Amendment does
Not what they say, what they did
I want to
or didn't
direct you
do.
back to paragraph 30 of your complaint, where you say that the defendants were keeping the whereabouts of Brian Laundrie secret, and it is believed were making arrangements for him to leave the country. So that's something that the plaintiffs themselves injected into the case. So that's the basis of my question, is now that you've put that fact into the four corners of the complaint, isn't that the basis for me to consider, without having to need a affirmative defense filed, if you will, the constitutional rights of the Laundries?
Judge, what's the crime committed there? What's the crime that if they are making efforts to try to remove him from the country? He's not been charged with anything. He's not a fugitive.
This guy is good.
There's not, that itself does not suggest that they were committing a
He was
crime.
never
There has to be an underlying
convicted. He was
basis.
dead.
If the complaint said there was a warrant out for Brian Laundrie's arrest and the Laundries were moving money around to try to move him out of the country, I agree with you wholeheartedly that you could arguably consider a Fifth Amendment argument
Hi,
in
Heather.
this case.
Welcome back.
But there's nothing in there to indicate that there was any criminal conduct on the part of the defendant. There's a statement that says they were moving money around to try to get him out of the country. Is that unlawful as it's pled in this complaint? No, it's not.
Okay.
Going back to the First Amendment issue, Your Honor,
The judge said, okay.
All-encompassing right to remain silent. Only where through state action they are being asked to espouse a religious, political, or ideological cause which they do not support do they have that right. And I will cite to you from one of the cases in my brief, my motion, the Overbay case, which says, freedom of speech includes both the right to speak freely and the right to refrain from speaking at all. At its heart, the right to refrain from speaking is concern for preventing government from compelling individuals to mouth support for views they find objectionable or mandating speech that a speaker would not otherwise make. In other words, the court continued, the right to refrain from speaking limits the government's ability to sanction or override a private individual's preference for not making certain speech. Not all speech, certain speech. So let's look at Overbay.
Mr. Riley, you have 5 minutes left, sir.
Thank you, Your Honor. Are the Laundries suggesting that we're seeking to compel them to mouth support for a view they find objectionable? Do they find it objectionable to tell a grieving family where their daughter's body is located and that that she's no longer alive? Do they find it?
And it's criminal.
Believe that they would have a personal individual preference for not making a statement that they knew where the body was located? That's ludicrous. The First Amendment does not apply in this particular circumstance.
Criminal.
We pointed out that they contacted counsel to show a course of conduct and to support our proposition that they knew that Gabby was dead and that they knew where her body was located.
Why would you get counsel?
They immediately contacted the
Duh.
I get
Thank
back
you.
To where's the duty, and certainly there's no legal prohibition on calling a lawyer.
I'm not, Judge, I'm not going there. I'm not suggesting, I'm saying that's support for our position that they knew. That's circumstantial evidence, in my view.
Because the lawyer said that at this time, they called him.
I'm not being critical
She was
of the
already
retained
dead
attorney. I'm
when
not
they
suggesting
called
they
him.
shouldn't have. I like the
He's
fact
right.
that they retained Attorney Bertolini, and Attorney Bertolini said what he said on September 14th of 2021. So we're not saying they shouldn't have hired an attorney. We're not saying hold it against them for hiring an attorney. I'm simply saying they hired one immediately after getting a phone call from their son, who then returned home without Gabby. Circumstantial evidence to show that they knew. That's the only reason that I raised
Judge,
that issue
get
about
this-
them hiring a lawyer.
Get this thing to trial. Come on. Wrap it up, because we need justice for this family and for Gabby.
Thank you very much. Thank you, Mr. Luca.
Press 1 if you think it's going to get dismissed, and 2 if you think it's going to go to trial.
Reply, but let's keep it to 2 minutes.
Yes, thank you, Your Honor. Your Honor, one thing I would point you to with regard to that City of Mineola case, Your Honor, there is a second DCA case, Crenshaw versus Sarasota County Public Hospital Board. I think it's cited in both my motion and the plaintiff's brief. And in that case, Your Honor, that case also involved a dead body, a stillborn child. And basically what happened is after the child was born, deceased, somebody within the hospital mutilated the child. It ended up going down a laundry chute. And in that case, Your Honor, importantly, the court noted that obviously if the mother had witnessed all of those terrible things that happened to the child, that might be one thing. But the court noted that the physically injured party should be directly involved in the event causing the original injury. If such a person sees it, hears it, or arrives on the scene while the injured party is still there, then that person is likely involved. And then they go on to say, here, appellant did not allege that she saw the mutilated body or that she was involved in the event, except for the birth of the stillborn child in any way. So, and Your Honor, that Stedman case was cited in Mineola, and in Mineola, the Fifth DCA said that to the extent that Stedman conflicts, they're not going to follow Stedman. But Stedman would control here because it is a second DCA case. And lastly, Your Honor,
what was that skip and a hop and a jump for?
get time to raise this initially, but I would point Your Honor to another important case. Mineola, the Fifth DCA said that to the extent that Stedman conflicts, they're not going to follow Stedman. But Stedman would control here because it is a second DCA case. And lastly, Your Honor,
sorry.
I didn't raise this, get time to raise this initially, but I would point Your Honor to another important case, which is MM versus MPS. It's a third DCA case from 1989, again cited in the papers. And although not perfectly analogous, that case is instructive because it involved the parents suing the defendant for something that was done to their daughter. And in that case, the defendant told the parents that he had sexually abused their daughter, but obviously the parents were not present for the abuse. In that case, the court found that the appellants were not present when the alleged mistreatment of their daughter took place and may not claim emotional distress for her injurious or offensive treatment. Now,
good God, he's making the worst cases.
The disclosure
examples of these
of their daughter was what caused their emotional distress. And the court said, after reviewing the law, we are unable to conclude that learning the awful truth from the defendant afforded appellants grounds for recovery for their own distress.
Look at him. Look at Gabby's dad. I can't remember his name. Anyway,
compensation for the distress
ready to get him.
They suffer when they receive bad news about family members, when there is no attendant intentional or reckless conduct directed toward them, an avalanche of litigation would ensue. Compensation is available for actual harm to the victim. Only in carefully prescribed circumstances is compensation permitted for relatives who suffer emotional distress. It is not lack of compassion, but necessity that restricts relief to the immediate victim. And Your Honor, in this case, I would just submit to Your Honor that allowing a cause of action like this to proceed would create an avalanche of litigation that the tort was never intended to cover. Thank you, Your Honor.
Thank you both for your arguments. I will do my best to get a written order out within 2 weeks of today. Anything else in this first case before we recess the first case?
No, Your Honor. No, thank you, Your Honor. May I be excused?
Yes, sir.
I don't represent any parties in the second case, so.
That's fine. While Mr. Luca is cleaning up.
Like, I want to punch him. Sorry, I'm just so mad that you're going to pick. And look, I know that you have to, that's what they practice. Lawyers practice to refer to cases in the past to help their claim. But my God, could you at least pick one where it's not... I mean, wouldn't you want to pick one where someone didn't do harm to them? You know, they were found not guilty by proof? I mean, I don't know. That hurt me a little bit. So, here's what we're going to do. Here's what we're going to do. What we're going to do. You get this, sir. This is what you get. I'm gonna leave that up here for a minute. He looks like he's imagining slamming his head into a brick wall on repeat. Yes, right? Yeah. So yeah, case studies or actual, you know, lawsuits and stuff like that. That's what you're supposed to do. But damn, that was brutal. And you're gonna do that right in front of the parents who has had to hear and had to wrap their head around the fact that their parents' son, Brian Laundrie, murdered Gabby, and they probably knew about it and the details while they were suffering. And that's the point. Like, they were suffering while they had him there. She didn't come back with Brian Laundrie. There should have been red flags right there, and there were. They should have called them to say, hey, have you seen your daughter? She didn't come back home with Brian. They had a fight or whatever. They stayed silent. It is not a secret at all that I'm 99.9% sure they knew. That's the thing. So let's see what the rest of it says. I just really wanted to put that picture up there. I'm not petty,
Is there
I promise.
anybody that's going to be here in the second case, which is Nicole Schmidt as administrator of the estate of Gabrielle Verona Petito versus Barry F. Spivey as curator of the estate of Brian Laundrie, case number 2022 CA 2115SC?
Your Honor, Patrick Riley on behalf of Nicole Schmidt as personal representative of the estate of Gabrielle Petito.
Okay. And has anyone appeared for the respondent?
No one, to my knowledge, has appeared. As Your Honor knows, Attorney Spivey, there was an order entered at the request of Attorney Spivey that because it was the Laundrie family who filed the objection to the claim that was made against Brian Laundrie's estate, they should defend the action. An order was entered appointing them ad litem to defend the action. It's been more than 20 days since I served the complaint on Mr. Spivey, but out of an abundance of caution, I'm giving the Laundries a period of time to respond, although the information that I have is that they are not going to and that a default will be entered.
Okay. Well, Deputy Velez, if you could sound the halls for Barry Spivey as curator.
I like that there's some camaraderie there. That's nice. I mean, you don't want to be
Okay, thank you.
Shitty
Court
to
Deputy
the-
advises, no response to the sounding of the halls.
to any of your
Well,
opponents, I guess.
What's your intentions then in this case, Mr. Riley?
Afro-human, yep.
Situation where, quite like this. So I don't think I'm obligated to give the Laundries 20 days from the time they were appointed as administrators ad litem to defend the action. But to avoid any future issues, I'm going to give them 20 days, and then I'm going to file for a clerk's default.
Okay. And you requested a jury trial in your complaint, I believe?
I did.
Okay, so we'll then have to have a jury trial on the issue.
All right.
Yes, Your Honor, we're going to
Woohoo!
be prepared to proceed to trial on that matter quickly.
Okay, well, I mean, it's a little premature relative to no default, but are you looking towards November, December, or what was your
I
trial?
without my trial calendar here, Your Honor, I'm not certain, but probably more likely sometime.
Hopefully
in
that's
early-
better. They turned down the volume on the
Well,
whoever's
I mean,
recording.
hopefully, for case managements in the future, you can bring your trial calendar.
I apologize.
Okay. Well, we'll wait and see whether you obtain a default or if someone appears. Obviously, if someone appears, I want you all to go ahead and do the case management order and get deadlines set. And so that we'll get the case rolling.
Yes,
If you
ma'am.
end up having a default, then we can set a trial. I don't think we necessarily need another case management.
Justice for Gabby and the
And we've
Petito
got a
family.
November
And the Schmidt family.
December 12th, then we'll, in the new year. See.
I can look at my calendar now.
Yeah. Well, I mean, I can't set a trial right this second because there's no default.
True. Okay.
But the reality is, because you requested a jury trial, we're going to have to impanel a jury on it, assuming that you're going to proceed with the case. I mean, obviously, if you decide not to proceed with the case, then we don't need to have it. But we'll call a jury, and we'll go from there.
Very well.
I highly doubt there's going to be a trial jury that's going to be like,
with all the other trials going on,
they didn't do anything wrong.
Judges are going to
Just
be
me.
here when, just need to start planning these things out.
I hope that doesn't mean what I think it means, but for next year.
I have no idea which judge is going to be here in 2023. That's the chief judge's prerogative.
Understood.
It
So
might be next
I will
year.
not reset a case management if Mr. Spivey or an administrator shows up. I'd ask that you go ahead and do a case management order and send it in, a report. If it is a default, send my judicial assistant word that the default has been entered, and a couple of dates on our trial calendar where you're looking for the trial to be had, and then we'll go from there. Assuming that there is a default, how many days of trial are you anticipating?
1 to 2 at the most. The witness list will be short.
I suspect jury selection will take us a little bit
Hey,
of time.
12-step, long time no see.
That's why I was saying 1 to 2, because I think I could try the case in a day.
Okay. Anything else in the second case, Mr. Riley,
No, Your Honor, thank you.
No? Okay. With that, we're going to be adjourned for the afternoon. Thank you all very much for being here, and have a good afternoon.
Thank you, Your Honor. You as well.
As we look here live, let's go live now to Pat Riley coming outside of the courthouse. There you see Nicole Schmidt.
See if they
her
have
husband,
something to
Jim
say.
Schmidt, that's Gabby Petito's stepfather. You also see Joe Petito holding hands there with Tara Petito, Gabby Petito's stepmom. So let's see. I believe Pat Riley is going to come on over. Let's listen in.
Good afternoon, everyone. On behalf of Joseph Petito and Nicole Schmidt, we just want to express our thank you to Judge Carroll for the time he gave us today on the motion. We appreciate the time it's going to take him to make his decision, and we have no doubt that he will make the correct decision. The family will not be taking any questions, but I'll do my best to answer a few questions if you'd like.
How do you think the court hearing went today?
I was very satisfied and pleased with the question the judge asked, in particular about the statement that Mr. Bertolino made on behalf of the Laundrie family, because that says a lot. The fact that they knew she was deceased, they knew where her body was located, and they had the audacity to express a hope that she would be reunited with her family.
How is the family holding up through all this?
As best I can tell, they're handling it as best they can. If you saw, there were some tears earlier today when we came in here, and I expect there will likely be some more tears.
I know that the family isn't taking anything, but I noticed Nicole was holding on to her necklace. Are you able to share if there's a meaning behind it?
It's her ashes.
It's Gabby's ashes. I'm sorry?
And the card.
Oh, it's a mass card. It's a drawing or a piece of art that someone from Australia, I believe, created utilizing a picture of Gabby. And on the back of it is a prayer that Jim wrote.
That's the most beautiful thing ever. I can't do this today, no pride. Oh, that's so pretty. And heartbreaking.
Well, there has to be an investigation or a crime before the Fifth Amendment right applies. I don't know, and I'm waiting for the day for the Laundries to tell us what crimes they committed. Hopefully they'll do that someday, but I don't know what crimes they are asserting were committed. We did allege that they were trying to move some money around to get Brian out of the country, but
yeah,
there was no
12
arrest
step. I
warrant
just
out for
didn't.
Brian.
I haven't seen you in a while, so
a criminal law
I didn't think you were
perspective, I
modding
don't think
at
that
all.
there was anything inappropriate about what they were
no
doing.
worries,
at
no
that
worries.
point.
We can talk about that later.
Is it upsetting not to see the Laundrie family present today?
I think for the Petito family it was a relief, but I would like to have had them be in the courtroom and face the people that they caused harm to.
How confident are you this will go in your favor?
Well, as I said, I like the questions the judge was asking opposing counsel about the statement that Mr. Bertolino made. If someone doesn't find his statements, knowing all the facts that were known to the Laundries at that time, if somebody doesn't find that offensive and outrageous, I don't know what's outrageous.
Did you read anything into the judge saying only 2 weeks to give a decision?
No, judges typically take cases under advisement when there's a lot of research.
They should have been in
cases
court.
cited,
Yes,
and so
ma'am.
I'm not
Yes,
surprised by
ma'am.
that at all. I'm surprised it's only 2 weeks. All right, thank you, everyone.
Wow. All right. Amazing.
Attorney Pat Riley speaking out.
All right, guys. So they're going to go to a trial jury for the issue at hand, which is, I guess, establishing that what had happened with the attorney's, the press conference release or whatever, the statement release. So I wonder when that's going to be. I didn't hear a date, so maybe they're going to get back and establish a date. I will let you know. I will make a video and post it on my community post, but I hope that this doesn't take more than 2 years for them to get, some justice in this way, So good for Andra. I heard her. I exited off and I was like, that sounds like Bullhorn Benny. So I'll message her. I already messaged her and took a picture and was like, I see you back there. So, having said that, guys, I'm going to wrap it up and make a little video for the people who don't want to watch my 1 hour and 5 minute live. But yeah, I will let you know. I really, really hope that, I hope they get every damn dime they deserve against those Laundrie's parents, because we all know they knew. They should have criminal charges. So the least that we can do is drain their wallets. And, I was there. We were all there. I'm pretty sure every single person in this chat or who is watching was there during the case, just hoping she wasn't deceased, hoping that they would find her, but knowing deep down that piece of shit, Brian Laundrie, did what he did, and they deserve justice, whether it be monetarily, because there really is no such thing as justice, but do what you got to do. We are all supportive of the Petito and the Schmidt family to get the justice that they want, and I will keep you guys updated as much as possible. All right, loves. Just making sure I didn't miss any comments. In a civil trial, do they have to show up at all? I'm pretty sure you do. I'm pretty sure that once it goes to a trial, you have to be there. You can't just not be there. I would assume. I'm pretty sure about that. But if I see anything different, I'll let you know. But I'm positive. I'm pretty positive. All right, guys. Thank you so much. Hey, Nancy. Glad you're here. Yeah, I'll keep you updated. Thank you so much for sitting there with me through that whole hour. As I say, hug yourself, take your vitamins, drink some water with those vitamins so that you can hug your babies, your grandbabies, your fur babies, and all the babies. And I will see you next time. Bye, everyone. Love ya.